name is Jennifer Parrish. I'm the Director of Criminal Justice Advocacy at the Urban Justice Center Mental Health Project, and I'm a member of the New York City Jails Action Coalition. And the Mental Health Project, we monitor the Brad H. lawsuit, which requires the provision of discharge planning services to people with mental illness. And we talk to people repeatedly, week by week, about the mental health care that they get and that they don't get, and what's going on in solitary confinement. And I'm here today because so many people are suffering in solitary confinement cells at Rikers Island. That's why I'm here, and that's why so many other JAC members are here as well. Because we know these people. We've talked with them. We have witnessed the torment that they experience in solitary confinement. And you might be thinking, why are you talking about solitary confinement? We're going to do something about that, but this hearing is really about ESHU. I have lots of concerns about ESHU. I refer you to our written testimony as well as the JAC testimony and everything else that advocates are saying to you here. But solitary confinement is the human rights violation that's happening right under our noses. And for us to walk away from this process in January and be left not with meaningful limits on that practice, but with more restrictions on incarcerated people, with a new form of deprivation of liberty, is simply unconscionable. The Commissioner assures you that after ESHU is adopted, then he will limit solitary confinement to 30 days. Then he will create punitive segregation light. Then he will get to reforms. We cannot accept assurances. We need rules. We can't accept assurances. You can't have a handshake agreement on torture. We've had those assurances. In fact, we were told that DOC would end the practice of placing people in solitary confinement for time owed from a previous incarceration. In fact, the previous commissioner told us that. She announced it in public that she was ending it, but she didn't. Commissioner Pont also said from the beginning of his tenure here that that's an unreasonable thing to do, but thus far he hasn't ended it. The Legal Aid Society brought a lawsuit this fall because the practice persists. Only now are we recognizing the rule change that everyone agreed was obviously needed. Hundreds of people must have suffered in solitary confinement as we waited for the promise of reform to become a reality. With this department, we need more than assurances of reforms to come. Jason Echeverria died in a solitary confinement unit for people with mental illness. He needed medical treatment, but was locked in a cell and ignored. Terrence Pendergrass, a man a jury found guilty beyond a reasonable doubt of causing Jason's death. Terrence Pendergrass kept working for this department, demoted from a captain, but still working as a correction officer with people for whom he had utter disregard. You must enact the standards that end the torture of solitary confinement. You can't leave it for the future. And then you must provide the oversight of those rules to ensure that the suffering ends. You can spur the culture change that we desperately need. And I ask you to do that.
Thank you. Our next speaker is John Boston, followed by Sarah Burke.
Good morning, everybody. Thank you for the opportunity to be here. I'm John Boston from the Prisoners' Rights Project of the Legal Aid Society. We have a little bit of experience dealing with the jails in various ways. And we hear every day from people who are held in them. I am not going to talk so much about the substance of the proposals before the board as I am before the way I think you should approach your task here. We think that you should vote these proposals down for reasons we've set forth in the written comments that we've submitted, and also for the reasons stated very eloquently by Dr. Selling. And I should add, by the way, I'm shocked to hear that the city is not allowing the Department of Health to be here. And I would strongly suggest that you tell the department, that the city, that you will not vote on these proposals until and unless you have had a candid presentation from the Department of Health. I think, But let's assume for the moment that you're not going to do what we say and you're not just going to vote these things down. I'd like to talk about how you should approach if that's not the case. You should not vote up or down this whole package. You should separately consider and vote on each element of the proposed amendments, and you should determine which of them are actually necessary and consider the potential harm done by each element in making your decision. You should not accept broad exemptions of enhanced supervision housing from standards requirements. You should make sure that each deviation from the present standards that you choose to countenance are spelled out very specifically. And here's an example of the approach I'm talking about. The recreation standard, number 106, the proposed revision says only prisoners confined in close custody, enhanced supervision housing, or punitive segregation shall be permitted recreation only in accordance with the provisions of subdivision C of this section. Well, right away, they're saying treat ESH like punitive segregation with regard to recreation. Well, your own staff report issued some months ago demonstrated what a colossal failure the recreation program in punitive segregation is. Do you really want to allow that to be replicated? I would think not. But moving on, the subdivision C, that is the only thing that is to continue to bind these housing areas, says only recreation period shall be at least 1 hour. Only time spent at the recreation area shall count for the hour. Recreation shall be available 7 days per week in the outdoor recreation area, except in inclement weather when the indoor recreation area shall be used. That leaves out a few things, a lot of things, in fact. For example, subdivision D of that section of the standards says that there must be indoor and outdoor recreation areas of sufficient size to meet the requirements of the section, and also an outdoor recreation area must allow for direct access to sunlight and air. Is the department going to be excused from those requirements for this population? Why is that necessary? There may be a reason, but I haven't heard one. Or the other subdivision, E1, which provides for access to table games, exercise programs, and arts and crafts activities. We understand, no paintbrushes, get that point. But are they not going to be allowed in the free time that they have, because with the best of intentions, they're not going to fill up all the time with programs? Are they not going to have these simple ways of keeping people occupied and out of trouble? Why is that needed? Ask that question, and if you don't have an answer, you shouldn't allow it. Now, what is left out of the proposed amendments is, if anything, more important than what's in them. There are a number of things that are necessary if DOC is going to expand its world of restrictive housing. For example, exclusion of persons with mental illness, the ability of clinical personnel to divert people from those settings, mental health settings, adequate due process procedures, and a system of programs and incentives so people can get out of this kind of housing. These appear in the belated policy document that some of us received this week, but they need to be in the standards. Why? For the reasons that Dr. Selling stated. You cannot expect that the rules will be followed in units that are dedicated to people that the department has declared to be bad actors. This is where there's slippage. This is where the rules are ignored. This is where the bodies are buried, sometimes literally. And so you should therefore place all the safeguards that people have been discussing in the standards, and you should also go back to your punitive segregation work and address the issue of punitive segregation. Don't throw away the work you've done. That should be part of this process. And finally, when you've done that, you'll have something pretty complicated. You should allow another period of public comment so we can all look at it and see if what you have done adds up, if it makes sense, if there are things that are in conflict with other things, and you'll get a better product. Thank you very much.
Mr. Boston, thank you. In terms of the punitive seg reform, you're right, we've been working on it for a year now, and that's sort of been on the back burner, although part of this new rule does have DOC's proposal with respect to two limitations,
right.
Not 16 and 17-year-olds and ending owed time. And I know Legal Aid has brought a lawsuit on the ending owed time and the feds were threatening, and that lawsuit certainly regarding adolescents. Can you tell us what your proposed reforms would be, should we seek to expand the limits on punitive seg, which we certainly have the authority to do?
I cannot tell you in precise detail. My colleague Sarah Kerr can probably give you a better read on that. But I would say generally that all of the things that the Department of Correction has talked about in policy and has put forth to the State Commission, although not put forward in its presentation to the board, should be locked into the standards. And further, questions of the length of stay, 30 days or 15 days, there's a good argument for 15 days. Those should be considered. And also, I think that the question of the delivery of services, whether it's mental health services or just getting people to the recreation program, really have to be looked at, because operationally, your staff showed that the recreation program is a disaster. You heard what Dr. Selling has said about the delivery of mental health services in restrictive housing units. You've also heard what Dr. Selling said about about lock-in, lock-out, and what the reality is as opposed to the theory. Those are things that I think that you need to deal with in standards, whether they're governing punitive seg, punitive light, or enhanced supervision.
Thank you, Mr. Boston. Sarah Kerr, followed by Natalie Chen. Ms. Kerr.
Good morning. My name is Sarah Kerr. I'm an attorney with the Prisoners' Rights Project of the Legal Aid Society. John's my boss. Thank you for the opportunity to offer this testimony today. During this year, we have seen massive evidence of misconducts and the negligence of corrections staff. The evidence comes from many sources: the Department of Justice, the press, reports from experts hired by this board, reports from board staff, and at board meetings from members of this board who witnessed horrific conditions and responses to individuals incarcerated in our city jails firsthand. Yet the rule proposal that this hearing is about does not set standards to improve conditions for individuals in our city jails. Based on the number and validity of recent reports, the Legal Aid Society's contact with thousands of individuals incarcerated in the city jails, and our knowledge through repeated lawsuits of the reluctance to require a reduction of use of force by DOC staff or to hold staff accountable when they use excessive force, we do not believe that the city has based its request for ESH on accurate information or on any valid root cause analysis of violence in our city jails. This board must acknowledge the pattern and practice of violence, false reporting, lack of integrity, and overutilization of punitive segregation before relying on DOC data and discretion. Yet this proposal creates new punitive and highly restrictive housing where the board's minimum standards will not apply. It places serious restrictions on the liberty and dignity of individuals in our city jails without factual predicate. The ESH rule proposal is far removed from evolving standards of decency and humanity in jail management, and in fact contains no adoption of standards at all. The question for the board should be what the board standards must include so that ESH, if permitted, and other jail restrictive housing settings are humane and incorporate evolving standards of decency in jail management. We think that there are essential elements that need to be put into the standards. Limitations on criteria for placement into any restrictive housing. Limitations on time in any restrictive housing. Strong due process protections. Exclusion of vulnerable populations, and I do mean youth up to 25, and I do mean more than people that are, Axis 1 disorder. I'm not sure that's still correct, the DSM changed, but personality disorders and functional impairments and physical disabilities and people with developmental disabilities are a lot of the proportion of people in our jails who have a difficult time with the environment, and they should not be punished for that disability. Data collection and publication of data, training and competency levels, requiring competency of staff who work with specific populations in need. Staffing ratios should be in accordance with whatever the current standards are. treatment, programming, and individualized plans that include positive responses, pro-social skill building, earned incentives, and enumerated benchmarks for movements to less restrictive housing. And that doesn't mean giving somebody a list of things that you give them no means to accomplish. There should be minimum hours for clinical staff to be present in any restrictive housing in our jails. And there need to be then places for clinical interventions to occur. It can't be that to get to treatment, you have to be shackled and strip searched and moved when we know there's a lack of escort officers. There needs to be confidential settings within the units so that there is real access to treatment. What was that last one you showed me? Okay, thanks.
Thank you.
No, let me get to the end. The board should use this rulemaking process to strengthen the minimum standards. That's what it should be about. It should not be about removing the standards, which is what's been proposed. There need to be protections for vulnerable populations. But I want to say something to the members of the Department of Correction who are here. We share what should be a common goal, and that should be to make these jails safe for incarcerated individuals, for staff, and for the community. We are asking that this board and your union and the department and others involved recognize that intimidation, punitive responses, bullying, and force make your job less safe and more violent and make our jails more violent. The ESH is punitive and non-therapeutic. It is the wrong response, and the proposed rule should not pass this board.
If I could just ask a question to your colleagues, and I did defer to you with respect to your proposals for punitive seg reform, the limitations in particular. We have the DOC only proposed two, and those are the only two in the DOC proposed for your rulemaking on it.
Well, I have a whole list in my our testimony, but I think that there should be no longer than 15 days if there is going to be segregation, no more than 15 days in any 60-day period. And even in that time, there should be 4 hours of out-of-cell time during the day, and that should include the kinds of pro-social programming and the ability to move yourself to less restrictive confinement. So I think that's a radical change, but I think that is in accordance with what we're learning. It is not necessarily where departments have gotten to yet, but it is what the standards are aiming to in the international community, and it is an appropriate, I think, change to include in our standards to put us ahead. I think that we should exclude vulnerable populations. That should be people under 25. We've heard about the brain science that I am definitely not an expert in. I think that also people with physical disabilities and serious injuries should not be housed in restrictive confinement. Due process protections, I think, I would like to see them include the right to counsel. I would like to see them include, using law students in the city maybe under the direction of attorneys to represent people. We have people in our jails who often have a hard time advocating for themselves. They may not recognize their own mental illness. They may not recognize things that would mitigate a situation. They may be illiterate and uncomfortable in the position. They should not. It shouldn't be just a few people that get assistance. It should be the regular norm that we don't impose punitive segregation and isolation on people without looking at it carefully and providing them with assistance that is valid. I'm going to leave that there. I do really think that the limitations in the current rule, like that we would limit access to clothing that's already been purchased and is free from your family, and that people can't drop off magazines to you, and that that's really not recognizing that this is jail. This isn't prison. This is people who have just been taken off the street. Something bad has happened. They may be very upset. They need to see their family. They need to have the ability to gain possessions and things to make being in the jails more comfortable. And the idea that we would limit those things, I find, kind of outrageous. And I certainly hope the board does look at those standards individually and says, there's really no factual basis for these changes. Thank you.
Thank you. Our next speaker is Natalie Chin, followed by Rabbi Hart. I just wanted to add that I personally reached out to Commissioner Bassett about attending this hearing and providing remarks. She indicated that she would not be attending, and I wrote back and said that her voice will be missed. The Board of Correction, I guarantee, will be meeting with the Commissioner and staff in the Department of Health and Mental Health. Ms. Chin.
Good morning. My name is Natalie Chin. I'm a professor at Brooklyn Law School and also the director of the Advocates for Adults with Intellectual and Developmental Disabilities Clinic, also called just a clinic. And the clinic represents low-income New Yorkers and their families in a variety of civil legal matters that impact adults with intellectual and developmental disabilities. The clinic offers testimony today to ensure that the Board of Correction considers the unique needs of persons with intellectual and developmental disabilities who are in the custody of the Department of Correction. Ms. Hamill, you asked earlier today for specific categories of vulnerable persons who should be excluded, and I want to talk specifically to the population who has an intellectual and developmental disability. The clinic strongly opposes the board should categorically bar inmates with intellectual and developmental disabilities from punitive segregation and ESH as they formulate changes to the jail minimum standards. The proposed creation of a highly restrictive, segregated unit for those designated by the Department of Correction as, and I quote, the most violent inmates, fails to take into consideration the vulnerable population of inmates who have intellectual and developmental disabilities, placing this particular population at a greater risk of harm and victimization while failing to address their treatment needs. There are reported estimates that there are between 3% and 10% of inmates with intellectual or developmental disabilities, and that this population is overrepresented in the criminal justice system. There's a high correlation among offenders with intellectual disability with psychological disadvantage. They're more likely to be uneducated, unemployed, poor, have deficits in social and communication skills, and suffer from behavioral or psychiatric disorders. The board must consider the intellectual and developmental impairments of inmates when considering revisions to the standards. The U.S. Supreme Court recognized the mitigating factors that the criminal justice system must consider in the punitive treatment of prisoners with intellectual impairments. The court reasoned, and I quote, because of their impairments, by definition, prisoners with intellectual disability have diminished capacities to understand and process information, to communicate, to abstract from mistakes and learn from experience, to engage in logical reasoning, to control impulses, to understand the reactions of others. And the court continues, in group settings, they are followers rather than leaders, and their deficiencies diminish their personal culpability. The ability of inmates with intellectual and developmental disabilities to remain safe and to exert their right to personal decision-making may be compromised as a result of their disability, making this population a vulnerable target for solitary confinement and ESH. Some common responses that may affect the ability of inmates with intellectual and developmental disabilities to protect their rights include the following: the inability to understand explanations of disciplinary hearings, a vulnerability to sexual predators, manipulation by other inmates, and recruitment for gang activities, which specifically this ESH proposal speaks to, so they would be targets to this, waiving rights without understanding, difficulty resolving problems, or seeking assistance when needed. Further, individuals with intellectual disabilities are more likely to be maltreated, psychologically and physically abused, and are at great risk for personal or violent crimes. The board must reject ESH and the use of the rulemaking process to strengthen the jail minimum standards, and rather strengthen the jail minimum standards to ensure the health, safety, and security of incarcerated persons with intellectual and developmental disabilities. The board should consider the following proposals as they formulate these changes. Exclude specifically incarcerated individuals with intellectual and developmental disabilities. Implement stronger safeguards to ensure that persons with intellectual and developmental disabilities are housed in a setting that best ensures their safety and security. Implement habilitation services for persons with intellectual and developmental disabilities, and this has been talked about quite a bit today. Strengthen the training, screening, and assessment, but I'm speaking specifically to those with intellectual and developmental disabilities so we can identify this population. And in terms of the due process protections, there's a provision in the proposed rules that requires that a hearing has to be requested in writing. And when you're talking about a population with intellectual and developmental disabilities, that certainly would would impose any possibility for them having a hearing. So one suggestion is to eliminate any requirement that a hearing must be requested in writing, and this is to ensure that all persons have a right to request a hearing. Second, if there's any evidence of intellectual or developmental impairment, that the Department of Correction must provide a non-Department of Correction mental health professional to be present during the disciplinary process or during the process, including any related meetings, and also provide legal representation. Thank you.
Thank you, Mr. Bobby.
Thank you very much. Do you have any ideas of the prevalence of mental intellectual disabilities in the population?
So the greatest challenge with this particular issue is a conflation of mental illness with intellectual and developmental disabilities. So in 1991, this is 23 years ago, the state legislature requested that what's now the office that serves people with developmental disabilities to do a really large study on this specific population in the state prison system. That was 23 years ago. At that time, it was found between 1% to 3% of inmates in the prison population had an intellectual or developmental disability. But I have to stress, and this is in my testimony, that that particular study was only specific to the prison population. And when it was published, and this is 23 years ago, the study said, in the study, it was mentioned, a comparable study is needed related to local New York City jails, recognizing that there are both more persons with developmental disabilities incarcerated in local jails, and that in these settings there are far fewer protections for vulnerable persons. This was in 1991. The New York City has not conducted a single study focused on inmates in the jail system who are diagnosed with intellectual or developmental disabilities.
Our next speaker is Hans Menno.
Johnny Perez is here.
Oh, I'm sorry. Mr. Perez.
Yeah, how you doing? Thank you for having me. Thank you for giving me the opportunity to share my experience with you. My name is Johnny Perez. I'm the Safe Reentry Advocate at the Urban Justice Center. I'm also a member of the Jails Action Coalition. I'm also a student at St. Francis College, and I'm also a father. But more importantly, I'm also a person who was formerly incarcerated, having served 15 years in prison, 3 years in solitary confinement, 90 of those days on Rikers Island at OBCC at 5 Southwest. I had this great elaborate speech, but I feel the need to just scratch it and kind of talk to some of the things that was spoken earlier. You talk about due process. What does due process look like? It looks like you go inside and there's a hearing officer, and the hearing officer is related to the same officer that wrote the ticket, and he tells you that if you don't cop out to this, if you try to fight it, we're going to give you the maximum amount of time. There is absolutely no due process. You're not allowed to call any witnesses. You're not allowed to have somebody represent you or anything like that. You can't examine evidence, nothing like that. Mind you, I was 17 years old when I was going through all this. The appeal process looks like you have 30 days to appeal. We don't have no appeal forms. Use a blank sheet of paper, except that when you get inside the cell, there is no paper. And then you're not allowed to give it a pen because, quote unquote, you might actually do something with the pen to hurt yourself or hurt other people. So there is no due process. There is no due process at all. The cell is very, very, very small, very cold, very quiet. Sometimes it gets so quiet that you can hear your own heartbeat. Or sometimes it gets so loud that you actually have to go to sleep to the sounds of other men crying. The visits are, you talk about non-contact visits. There was times when, I had to go shackled to the visit, and my mother was not allowed to hug me. She was not allowed to kiss me. In the building where I was at that time, I would put my face through the bar, and my mother would just caress my face through the bars. She cried at the end of our last visit because after that I was sent upstate. Like I said, I did 15 years. I was sentenced 15 years for robbery in the first degree when I was 20 years old. School does not look like any kind of school that thanks God I'm receiving today. School looks like a piece of paper that is slid under your cell, and then the teacher comes back a week later and asks you how you're doing. I don't have a developmental disability or learning disability, but if I did, I can imagine that type of school having any type of effect on any educational pursuits or goals that I may have. The meals, my last meal was at 4 o'clock in the afternoon, with my next meal at 7 a.m. I have to be on my gate for the meal, and if I happen to oversleep because the light happened to be on all night because I couldn't sleep, or because I was being awakened every hour on the hour for the officer to make sure that I'm alive, then I don't eat. And if you do get that meal, then that meal is cold. Most of the time it's cold, but most of the time the proportion is so small that you end up losing weight. I went inside, I was about 180 pounds. By the time I went upstate and they weighed me at Downstate Correctional Facility, I weighed 155 pounds. I want to say something about those paintbrushes, right? there's this notion that people in prison are incorrigible individuals who are born with some kind of criminal gene that can't be changed. The opposite is actually true. Most of the people in prison are people who are disproportionately of color, who lack an education, who lack educational opportunities, who are basically just trying to do the best they can with what they have, and as a result, end up applying criminal solutions to their problems. If you give me a paintbrush, I'm not going to stab somebody with it. I might just become an artist, or I might just paint with it. I think that's important to keep in mind. I want to advise you and compel you and even urge you to strengthen the minimum standards, and also take into consideration not only to look at it from the perspective of someone who is directly involved, and make sure that those people have a voice in the conversation, and also listen to the advocates and families who are here today, especially the Jails Action Coalition and all the other advocates that are here.
Thank you, Mr. Perez.
Thank you.
The next speaker is Juan Meadows, followed by Sister Marianne Dubai.
Hello, how are you? My name is Hans Meadows. I'm the Director of Youth Services at the Center for Community Alternatives. Thank you for the opportunity to testify today regarding the enhanced supervision housing units. The Center for Community Alternatives has more than 30 years of experience working in the field of community-based alternatives to incarceration, and our mission is to promote reintegrative justice and reduce reliance on incarceration through advocacy, services, and public policy development in pursuit of civil human rights. So our programs primarily serve people who have been involved in the criminal justice system and are seeking community reintegration and productive law-abiding lives. We have considerable experience with people who have been detained on Rikers Island and have some significant concerns about the proposed rule change. But first, I want to applaud the general climate of change and the attention being given to 16 and 17-year-olds, and with the focus on preventing them from spending time in punitive segregation, or in any event, as the board is aware, these young people are a particularly vulnerable group and should be considered through this lens. However, because of the well-documented negative effects, we urge the board to reconsider the use of punitive segregation for all people, and certainly for people under the age of 25. As the science of brain development shows, the use of this harsh mechanism is harmful, and particularly so for young people. Therefore, the proposed rule, which allows for separation of young people over 17, still allows for harsh and irreparable harm to come to young people over 17 years old. So, the rationale for these rule changes seems to focus a great deal on the safety and the problems at Rikers. And based on my discussions with young people who've been on Rikers, and based on my discussions on people who are employed at CCA who have been to Rikers or spent time on Rikers, I think the focus on safety is correct. But despite the report of rampant and unnecessary force by DOC staff and a deep-seated culture of violence, it seems that the rule focuses on how to handle the people who are incarcerated rather than changing the culture and behaviors of the corrections officers who are charged with their safety and their care. I think this paradigm is incorrect, and we need to reconsider how we're focusing on the problems that exist within the facilities. I want to focus on some solutions to that. The staff, the correction officers, first and foremost, need ongoing and consistent retraining that refocuses on approaches that do not involve the use of force. Those in leadership, supervisory positions must hold corrections officers accountable and make it clear by words and deeds that the culture of violence will not be tolerated. Staff should be trained to recognize traumatic reactions that may influence both their behaviors as well as the behaviors of incarcerated people. And additionally, it should include discussions on basic human rights, de-escalation, crisis management, and finally, the overall framework should focus on methods to facilitate reentry and comprehend social justice. I think that last point, the facilitation of reentry, is something that CCA will focus on, and the idea that is often ignored and not considered. The people who are on Rikers are not there for life, but they are damaged for life based on their experience there, or can be damaged for life, and that needs to be considered, because we do need to wonder how will they reenter, how will they become part of the society again, and it's a major consideration for CCA and for many others. And the other flaws have been considered and have been discussed already by the Jails Action Coalition members and others who have already testified. But I do want to reiterate the idea that mental health concerns are often ignored and need to be addressed. We cannot continue to lock up people whose largest problem is their mental health and not anything that they have done or any act they committed. So in conclusion, given the findings of the Justice Department as well as the investigative journalists, we must thoroughly reform not only the culture and conditions at Rikers, but the overuse of detention in general and its disproportionate impact on marginalized, impoverished people of color. Thank you very much.
Next speaker is Sister Mary,
My name is Sister Marion DeFeast. I'm a sister of St. Joseph. On Rikers Island, where I worked as a chaplain for 23 years, from 1984 to 2007, the term for solitary confinement unit was known as the Bing. When I asked a correction officer why it was called the Bing, he replied, after a time of confinement, a person's mind can go Bing. Bing at the Rose M. Singer Center for Women consisted of a housing unit with 50 cells. The adolescent girls were in a separate unit. The women were locked in their cells for 23 hours and allowed 1 hour in an outdoor area for recreation. Meals were slipped in their cell through a slot in the door. I recall having to take a deep breath before going into the Bing. The noise level was either deafening due to women yelling to be heard from one cell to the other, or deathly silent during count time when all activity ceased. I recall going from cell to cell speaking through a small glass pane. Usually I arrived with a supply of stamped envelopes and asked each woman if she needed anything. Some asked for a prayer, which was said through the glass. Many of the women had a glazed look, which indicated to me a deep depression. The confinement usually lasted 10 days, a month, or more. Because there was danger of mental breakdowns, which could lead to suicide attempts, inmates were recruited to act as suicide prevention aides. Their task was to make repeated rounds of the cells and report any suspicious actions. If after speaking with a woman with whom I feared was decompensating, I would go to the mental health director or to the warden and voice my concerns. After an assessment, an inmate might get a time cut, or she might be removed from the unit. One day, as I approached the solitary confinement area, a woman was sitting on the floor, gasping for breath. She had an asthma attack while in her cell and was pulled out to get some air while she awaited the arrival of a medical team. Also around that time, I had learned of a pregnant woman who had gone into labor while in her cell. A captain making his rounds avoided a tragedy by getting her out and into the clinic. A woman could be sent to the Bing for minor offenses, such as talking online in the corridor or for having unauthorized clothing or food in her cell. I had sensed that the discipline of solitary confinement was barbaric and inhumane, but I saw it as departmental policy, and therefore there was nothing I could do to ban the practice. Unlike the Rockefeller drug laws, which I worked to reform through enlisting the aid of outside agencies, I felt powerless regarding solitary confinement. How does one go about changing department policy? When I retired from the department in 2007, I presumed that my involvement with the criminal justice system was over. Not so. 3 years ago, I read a request from the National Religious Campaign Against Torture asking that a petition be signed to prohibit the use of prolonged isolation. It stated that according to the Geneva Conventions of the United Nations, solitary confinement of more than 15 days is considered torture. Although we as a nation signed the Geneva Conventions, we are presently in violation of them. It is no wonder that I felt so uneasy walking into the Bing. Without realizing it, I was a witness to torture. I also realize now that we can change policy by enacting laws. It is heartening to know that the steps are being taken to educate the public regarding the use of solitary confinement. Some of these steps, of course, include instructional DVDs being circulated, articles and editorials are appearing in the newspapers, panel discussions are taking place in parish halls, and congressional leaders have held hearings. Through the efforts of many organizations, including the American Civil Liberties Union, the Human Rights Watch, the New York City Jail Action Coalition, consciousness is being raised about this issue. However, it is distressing to learn that just as many states, including Maine and Mississippi, Colorado, New Mexico, Washington State, and statewide campaigns for alternatives to isolated confinement are working successfully to decrease the number of inmates in solitary confinement and to improve conditions in the unit, the opposite is happening in New York State. Although the census has dropped dramatically on Rikers Island, due in part to the reform of the Rockefeller drug laws, more cells are being requested for the creation of enhanced supervision housing units.
Thank you, sister.
Could I just end with this?
Very brief.
Yes. Perhaps we who pride ourselves on living in the most liberal, progressive city in the world could send a delegation to Mississippi or Maine to learn how to run our detention centers as they do, that is, humanely, without resorting to the use of torture. It is my hope and prayer that we will soon end the barbaric practice of solitary confinement in our jails and prisons. We must affirm that every person is made in the image of God, is a child of God, capable of redemption, and therefore is worthy of our respect, protection, and compassion. And I thank you.
The next speaker is Mary Buser. Mary is Buser, followed by Walter Higgins and John Clifford. Buser.
Thank you. My name is Mary Buser, and I worked in the Rikers Island Mental Health Department for 5 years during the Giuliani administration. In my final stint on Rikers, I was acting chief of mental health in the Central Punitive Segregation Unit, best known as the Bing. My experience in providing mental health services to punished inmates was so profoundly disturbing that I wrote an op-ed piece on the horrors of solitary confinement that was recently published in the Washington Post. I have also written a book about my work on Rikers, which is to be released in the fall of 2015. With recent media attention highlighting the inhumanity of solitary confinement, I find it stunning that the Department of Corrections is not only turning its back on meaningful reform to this cruel practice, but is proposing an additional modified version of the very same thing. While there have been some concessions to solitary for pregnant women, adolescents, and the mentally ill, I would like to stress that this punishment is not only inhumane for the mentally ill, but for everyone. It was my observation that under the stress of solitary, those with no prior mental health issues develop devastating symptoms very quickly, the bleakest of depression, plunging despair, and terrifying hallucinations. The mental health department was a constant presence in the Bing, doling out antidepressants, antipsychotics, and mountains of sleeping pills. But even the most potent medications reached only so far, and when normal human behavior deteriorated into frantic scenes of self-mutilation and makeshift nooses, as it often did, we were called to a cell door to assess the situation. In doing so, we were in a position to authorize a temporary reprieve, but only if death seemed likely. I would like to read a short excerpt from my forthcoming book that describes a typical cell door scene. Dr. Diaz, a seasoned Bing psychiatrist, points to a door that's slightly ajar. "We got a head basher," he says to me. "His name is Troy Jackson. He's been going downhill for a while now. I've upped the meds, changed them, we've talked to him, but we're out of options. He's been in for 2 months now." I wince at the length of punishment. 2 entire months inside a cramped cell with 1 hour of rec, which amounts to a shackled walk to an outdoor cage to stand alone and glimpse the sky. Although the maximum punishment for any single infraction is 90 days, there's nothing to keep infraction tickets from piling up, and there are those in this unit who face years in solitary. All right, let me talk to him, I say, with some vague hope of dispensing calming words that it might enable him to hang on a little while longer. The officer pulls open the creaking door. Inside, the walls are smeared with blood, and a black youth stands trembling, beads of sweat dripping from his chin, blood seeping through his scalp. He's barely out of his teens. Please, miss, he whispers to me, help me. For a moment, Troy Jackson and I stare at one another. As his eyes plead with mine, the blood is running down behind his ears. I feel a clutch in my throat, but remind myself that I'm not here to get to know him or even to find out why he's in solitary. I'm here to make sure of exactly one thing, that he remains alive. I can't, he whispers. I'm telling you, I can't. The blood is trickling down to his eyes now. I realize we're well beyond any therapeutic dialogue. Okay, just give me a minute here. As I step out to confer with my colleagues, I hear a loud moan, and we rush back in just as the young man's head thuds against the concrete. Troy Jackson crumples to the floor, the blood freely spilling, the gash in his scalp revealing a wide patch of glinting whiteness. This story continues as our mental health team wrestles with the decision that we must make. Tragically, this vignette is neither isolated nor unusual. It is everyday behavior in a solitary unit where blood, nooses, and agonized shell-shocked faces are the norm. In a civilized society that prides itself as progressive on human rights, a punishment that induces this level of suffering is simply unacceptable. Having spent several years of my waking life on the inside, I fully appreciate the need to maintain jailhouse safety and punish the recalcitrant. But instead of this regressive proposal, I would challenge the Department of Corrections to lead the way in devising humane methods of accomplishing this. Thank you.
Our next speaker is Walter Higgins. Walter Higgins here. Mr. Brickman, who was a former executive director of the Board of Corrections.
I've been called many things.
I apologize.
Good morning to you all. My name is Walter F. Higgins, a concerned private citizen. I'm here on behalf of the St. Boniface Pastoral Parish Council's Social Justice Committee, a member of the National Religious Campaign Against Torture, to express my bewilderment and moral abhorrence over the continuation of the penal policy of solitary confinement in the New York City's Department of Correction. Conditions of extreme isolation where incarcerated human beings are confined and constrained to exist for 22 to 23 hours a day in a 6 by 9 foot prison cell, which is about the size of a Manhattan bathroom in an apartment. Solitary confinement, extreme isolation is harmful and injurious, and has promptly been described by the professional cadre during this hearing representing fields of psychiatry, sociology, and psychology as torture, and as such is highly destructive of a person's very humanity. Torture is a very charged word. It suggests a well-deserved despicability over those who employ it, and equally to those who turn a blind eye to its existence despite full evidence of its inexplicable continuance. It appears to this observer that there's a callousness as to how we treat allegations of torture in the solitary confinement context we are discussing here this morning and afternoon. Professionally, I have been an electronic journalist, a news writer for the CBS Morning News with Mike Wallace, and Walter Cronkite's anchoring of the CBS News special coverage of this country's Gemini and Apollo manned space programs. I am a pro bono professor at Brooklyn College Lifelong Learning Institute, where I teach retired executives about American government and history, our Constitution, and the United States Supreme Court, and other courses that I have carte blanche to create especially for them. Speaking from my own faith tradition, the Golden Rule expresses the concept, do unto others as you would have them do unto you. So I am compelled to ask if any of today's hearing panel would subject themselves to such a penal policy willingly. In resolving that rhetorical question, allow me to point out that the executive director of the Colorado Department of Corrections, Rick Ramick, gave testimony before the February 25, 2014 Senate Subcommittee hearing on solitary confinement. During his testimony and in a New York Times op-ed entitled "My Night in Solitary," Ramick described his experience of spending over 20 hours in administrative segregation. When I finally left my cell at 3 p.m., he said, I felt even more urgency for reform. As a person of faith, I join my colleagues here this morning in calling for the eradication of the use of solitary confinement and its continuance as penal policy. In addition, I call on the New York City Department of Correction not to move forward with the creation of ESHU enhanced supervision housing units, yet another euphemism in my mind to torture. Adding additional restricted housing units at a time when we need to be eliminating entirely the practice of isolation in exchange for rehabilitative practices that ensure detainees and staff are safe. Man, to be clear, is made in the image and likeness of God. All people are infused with dignity that cannot be denied. The continued use of solitary confinement in New York City's jail system is inhumane and must be brought to a halt. Thank you for your courtesy of your attention to my remarks this morning. May your holiday season be a happy and joyous one, and may the new year be blessed for you and for those important to you, and to those who we incarcerate. As a postscript, because of the time constraints mandated for this morning's session of testimony, I will submit my fuller written testimony and the op-ed piece I wrote on the subject of solitary confinement, and which was published in the Daily News a year and change ago. As a final postscript, please note that I will also send my views on the subject to the executive producer of 60 Minutes, which today occupies the hallowed tradition of CBS reports in matters of documentaries and investigative reporting, so that a fuller light can be cast on our city's horrific policy of penal torture. I thank you.
Thank you. Our next speaker is John Brickman, followed by Jack Beck and Deborah Hertz. Mr. Brickman.
Mr. Chairman, members of the board, I am John Brickman.
Thank you.
And from 1971 to 1975, I served as your first executive director. In the 40 years that have followed, I've remained active in the civilian oversight of jails and prisons. So I hope that my experience can add some historical perspective to the discussion today. You as a board are most effective, and you have the best chance to bring about change when you maintain your distance from the Department of Correction. There needs to be a tension, a healthy tension, between the board and the department. In the 5 decades since Mayor Lindsay revitalized the board in 1970, the board's greatest impact has come when it has asserted its independence from the department and indeed from City Hall as well. An experience unfortunately shows also that when the board ceases to serve as an activist foil to the department, the spark, and that's happened over the years, the spark is missing and the board is ineffective. And that's true even when we have a commissioner, such as Commissioner Pont, whose outlook and commitment to change are extremely encouraging, as he is. If the board abandons its mission to bring progressive change, a right for which we fought so hard when 40 years ago we won the battle to empower the board to set minimum standards, then if that happens, the board fails in its purpose. Now, when the board sets standards, it properly gives great weight to safety for inmates, for uniformed staff, for civilian workers. But here, as everywhere else, there needs to be a balance between security and the humane treatment of people. You, members of this board, have to ensure that balance because in this context, no one else will. You will lose that balance if, for example, and this is only an example among the proposed changes, you abandon the board's decades-old insistence that inmates and their families and their visitors have contact visits except under very limited circumstances and with prescribed proof. The proposal you consider would turn on its head for ESH prisoners the procedure for contact visits and permit denial of contact visits before any determination that a visit would endanger security as under the current rule. we don't know if the determination to allow contact visits would be placed in the hands of relatively low-ranking personnel, but I suggest that in light of recent history, that might be a process that is not in anyone's interest. My point today is not to debate whether the proposed rule change is good or bad, although I believe that it isn't good, because the goal of reducing punitive segregation hardly justifies bad alternatives, but rather to urge you to go about it differently. It doesn't make sense to put up the proposal in November, to talk about it in December, and to vote on it in January. That's what lawyers call the rocket docket. Here, you need the kind of analytical development and open debate that have characterized the board's adoption of the rules originally in the 1970s and its later decisions regarding rule changes and variances. In 2007, for example, you spent the better part of 2 years discussing and weighing the issues before you acted on rule changes. Now, the debate today is a good start, but if you adopt the present proposals uncritically, you force a sea change in procedure, one that neither elevates the process nor distinguishes the board. Effective oversight of jails and prisons, in my view, invokes von Heisenberg's uncertainty principle. That's the rule of physics that tells us that subatomic reactions vary simply because the scientist is watching them. And von Heisenberg's principle has startling relevance to the closed world of jails. You are the scientific observers, and your presence has an impact on what you are watching. But there's much more to your role simply than watching. And I mean no offense when I ask these questions. Why did the revelations of facts about the horrific treatment of prisoners about which the board had to know come from the New York Times and not the board? Why did a line in the sand get drawn by the United States Attorney, not the board? This board has to assert itself as an unfettered voice, so there will be no need to ask such questions. You can affect what you see only if you maintain your independence and your willingness to speak the truth as you see it.
Thank you.